Child support is calculated based on two things: income and the amount of children. With regard to children, it's 17% for one child, 25 for two, 29 for three, 31 for four, and 5 or more, even if you have 10 children, it's 35% of your income after deduction of FICA. So about 93% of your income will be counted. Not your net income, 93% of your gross, if you're the person paying support. What else counts? How much did you make? Now, is it everything, every dollar? What if you make $500,000? Will it all count? And the answer, like many things, is that depends. The court must calculate child support on the first $183,000 of combined income. Will the court go over that cap and use all or some of your additional income if you go over that? The answer is usually yes, but a lot of that depends on where you are in New York. Some places are more expensive, how much does the other party earn, and how much time is spent between the two parties, all of which will be considered by the court with a bunch of other factors. Can child support be modified? Yes. Under the law, child support can be changed by either party's income changing by 15% or the passage of 3 years. Many people's agreements, when they resolve it, will waive those standards as a means for modifying. It also can change if there's been an unforeseen and unanticipated change in circumstances. What could that be? It could be many, many things, but it would be your burden to prove before a court. What happens if child support payments are missed? Nothing good. Look, if somebody misses a payment by a month or a couple of months, or they're late, not much is going to happen. Nothing is going to happen if the person receiving support does not file an application for enforcement. There's nobody watching. Child support enforcement unit will do something eventually, like suspending a driver's license or putting a freeze on a tax refund. But if there's been systemic non-payment, you need to file for enforcement. What comes from that enforcement is an order of contempt. Their non-payment is deemed to be, quote, willful. They then have to prove why it's not willful. If that party's not paying support and they had the means and the opportunity to do so, they could face jail time. It is a long process, and a lot of people will say the court will do nothing, but that's simply not true. But the burden is on you to prove it, and it's worth it at the end. What if you're the person who's paying child support and something has changed, like you lost your job? Don't sit there just with this inability to pay. You have to run and file an application for a modification. In this case, it's a downward modification. Your cause is that you have lost your employment through no fault of your own. This doesn't apply if you quit your job. A person can't just say, I'm not going to work. I'm just not going to work and I'm not going to pay child support. There will be dire consequences. But if you legitimately lost your income and you can't pay, you have to ask the court to modify your order. If you have questions about child support and you're in New York, call us at the Sclavos Law Group.